this is our last panel before Representative Pallone. Howard Shalansky is not able to join us. I am sorry to say he had warned me this was a possibility, that a set of things that are beyond his control, something that he absolutely had to attend, got moved to this time slot, and I apologize on his behalf. Fortunately for us, we have two quite interesting people, the Johns, who are general counsels, as you all know, of two entities that are quite significant in this space, the FTC and the FCC. Let me remind everybody in the room something that I suspect you all know, which is there's no point in asking, when we get to the Q&A part, no point in asking them any question about anything that's actually pending at either of their commissions, or that's a live topic right now of pending regulation, because you're not going to be able to answer your question, so not going to be interesting for anybody to talk about things that are happening immediately before us. And of course, part of the reason we want them here for this conference is we want them to be talking about what's on the horizon, what's actually coming down might be coming down the pipe, we should be thinking about in the future, not what's actually before either of them today, which, again, A, they can't talk about, and B, everybody's already locked in on their talking points anyway, so it wouldn't actually be a terribly interesting conversation. So John Nuechterlein will go first, then John Sallet. I will have some questions, and then we'll open it up to the audience without any further ado. John.
Thank you, Stuart. Great conference. I didn't go to Duke, but my wife did. So just an obligatory connection that I would mention. I'm going to start with a disclaimer, which, as Stuart mentioned, I'm the general counsel of the FTC. I am not here in that capacity. I'm here in my capacity as a longtime telecom policy wonk. I was a practicing telecom lawyer before I joined the FTC, and these issues have been interesting to me for a very long time, but I'm here talking only for myself. The topic of this panel is what metrics or modes of analysis should we use to think about future regulatory issues arising in the video space. And the mantra that I think almost everybody agrees with, the objective is competition, competition, competition. I'm not the first to say it, but I think that that mantra has almost universal support. The question is, what does it mean, competition, and how do you achieve it? And to me, the metrics or modes of analysis, to use the buzzwords that define this panel, that will enable us to tell whether policy advances competition is antitrust, antitrust, antitrust. In particular, rigorous antitrust economics, and I'm going to talk a lot about that in a minute. But when I say antitrust, I'm not making an institutional point, and this is very important. I'm not saying that telecom policy ought to be given over to generalist antitrust agencies. I am saying that the modes of analysis that whatever agency uses to address these issues should be very similar to antitrust modes of analysis. So I'm going to make a couple of threshold assumptions in my talk. The first I'm going to make is that over-the-top video is going to be an increasingly important part of the video ecosystem. I think there's widespread agreement with that. People can disagree about the pace in which OTT becomes the dominant mode of distribution, but I don't think anyone can really disagree that the trajectory is towards greater use of OTT. I'm going to make another assumption, which is that the existing FCC regulatory regime, the one adopted last year earlier this year and in previous years, will remain intact. That the broadband ISPs will remain subject to Title II. I'm not going to necessarily make assumptions about what that means, though. One of the, and I think this may be in partial answer to a question that was asked at the previous panel. I don't think that the mere fact of reclassification of broadband ISPs actually by itself changes anyone's business plans in any significant respect. There might be exceptions on the margins, but the mere fact that ISPs are now under Title II doesn't necessarily mean that they are substantially more heavily regulated than they were before. They were previously subject to regulation under either ancillary authority or 706. They're now subject to regulation under 706 and Title II. But the question is what the FCC does with Title II authority. Under the mode of Title II regulation that the wireless voice ecosystem grew up with, it might not mean very much at all. Under the Orloff doctrine, Orloff is a case decided by the FCC and then later by the DC Circuit, Title II can be applied in such a light touch way that it almost never affects substantive business outcomes. So the question is how Title II will be implemented. Will it be implemented in ways that, for example, begin to merge into rate regulation or not? So what are some of the emerging issues that we're going to see in the next few years? Stuart asked me to focus on the intermediate term, not the really long term, not this year, but next few years. One of them, a couple of them can be classed under the heading zero rating and data caps. Zero rating is a business model in which an ISP, often a mobile ISP, partners with a content provider to offer particular content streams without having those streams count against data caps. Data caps, as the name suggests, can be either a hard or a soft method of constraining user usage of a broadband service after they've reached a certain amount of usage, usually per month. That there have been legitimate concerns expressed about the ability of ISPs to use these mechanisms to discriminate against unaffiliated third-party OTT providers. And that's one of the issues on the table. What modes of analysis would I recommend for judging it? Well, there turns out to be an extensive literature on vertical relationships in the antitrust world. So, for example, an antitrust economist in this context would examine in what circumstances a platform provider with market power has the incentive and the ability to harm consumers through inefficient discrimination against complementary applications, such as third-party over-the-top video services. There's not a simple answer to that question, and it often turns out to be very context-specific. Note also that I said inefficient discrimination against complementary third-party video services. Some discrimination, if you want to use that term, in favor of affiliated content or applications by a platform provider can, in the ultimate analysis, be pro-competitive, pro-consumer welfare. It depends on the facts. Sometimes it's anti-competitive. You need to look at the facts. Paid peering and interconnections, Christopher, you pointed out in the previous panel, is another set of issues that's arising now. Broadband ISPs operate in a classic two-sided market. They serve consumers, and they receive content from video CDNs, among other networks that give them incoming traffic. So there's a rich economic literature on this issue as well, double-sided markets. What are the contexts in which prices on one side will improve pricing outcomes in a way that enhances consumer welfare? There's something called a seesaw principle, under which in many circumstances, higher prices on one side of a double-sided market will lead to lower prices on the other side of a double-sided market. And there are close technological questions presented here too. So for example, does the availability of multiple transit routes into a broadband ISP network discipline the price of paid peering arrangements between content-oriented or video-oriented CDNs and eyeball ISPs? Are those reasonable substitutes? Best effort transit versus direct interconnection between CDNs and ISPs. These issues are incredibly complex, and they're not susceptible to categorical answers. Luckily, antitrust economics has decades of experience with analogous issues in market contexts across the economy, and it provides the analytical tools for understanding them. So those are the modes of analysis that I would look to help unravel some of these hard issues. Here are some modes of analysis that I would personally prefer to hear less of. And a lot of this just turns on jargon that you hear a lot in the policy debates, jargon that's not matched by any underlying substantive content. So for example, one form of jargon that I would prefer to hear less of is jargon about tolls or double recovery. The mere fact that money flows from an interconnecting CDN to a broadband ISP does not itself mean that consumer welfare is harmed. These are two-sided markets, and shutting off interconnection recovery from one side of the market doesn't necessarily produce optimal economic solutions. It might, depending on the circumstance, but it's a close question and it's context specific. Sometimes closing off such payments on the content side of the market could produce inefficient cross subsidies. Sometimes it wouldn't, sometimes it would. Another buzz term that I prefer to hear less of is language, rhetoric about how we should be leveling, using the regulatory apparatus to level the playing field between large media companies and small startups in dorm rooms or garages. And the premise of the modern economy is that the capital markets are at least reasonably efficient, and that entrepreneurs with promising business plans can generally obtain the capital they need to compete with established players. And so there's no basis for rejecting market arrangements simply because they involve the payment, direct or indirect, of fees or tolls by content providers, or simply because some content providers will not come to market if they have to pay such fees. The question, again, is what sort of arrangement increases consumer welfare? The fate of individual competitors, large or small, is not dispositive of that question. In addition, I would prefer to hear less, I prefer that there be less reliance on the concepts of gatekeepers and the terminating access monopoly. Christopher, you and I have co-authored a paper that will appear later this year in the Colorado Technology Law Journal. That's the Phil Weiser organ that used to be called the Journal of Technology and Telecommunications and High Tech Law. The terms gatekeepers and terminating access monopoly have a place, but they tend to obscure more than they edify. There may very well be concerns in the broadband ecosystem about plain vanilla monopoly power of the sort enjoyed by very large ISPs. There may also be monopsony power by very large ISPs or MVPDs, but those economic issues are conceptually distinct from the gatekeeper construct, which theoretically, as it has been used in some of the literature, suggests that any ISP, no matter how competitive the retail market that it competes in, and no matter how small it may be, nonetheless has some sort of special gatekeeper power with respect to interconnecting content providers. I think that concern is overblown. We have gatekeepers throughout the economy. HBO is a gatekeeper for HBO content. The business negotiations between companies that could plausibly be called gatekeepers can produce very efficient outcomes without regulatory intervention. Normally, there needs to be some true form of monopoly power or monopsony power before it becomes efficient for the government to intervene. And finally, of the forms of rhetoric that I hope to hear less of, I really hope to hear less about the First Amendment in this context, where I believe that the extension of the concept to economic relationships is highly attenuated. We are seeing that now most prominently in the judicial challenge to the FCC's open internet order. One of the parties, not the main ISP brief, but a separate ISP brief, makes the argument that the FCC has violated the First Amendment by constraining the supposed editorial discretion of ISPs that have never claimed to be exercising editorial discretion in the first place. I am in violent agreement with Stuart Benjamin, who has written an article on this in, 2011? that explains why the First Amendment is misplaced in this context. The thing that's troubling to me about irrational extensions of First Amendment concerns is simply that it tends to be a conversation stopper. These are very interesting, nuanced economic and technological debates. When you invoke the First Amendment to shut down that debate, I think a lot of the nuance gets lost. A lot of the issues that we care about could potentially be silenced, and all in the service of a set of First Amendment rules that don't actually serve the underlying principles of the First Amendment. I don't think anyone seriously believes that by adopting the Open Internet Order, the FCC has somehow chilled robust debate in this country. So that's my wish list of metrics or modes of analysis that I hope to hear more of, and metrics and modes of analysis that I hope to hear less of. I was going to talk briefly about retransmission consent and the compulsory copyright.
Wow.
Howard's not here, so we have extra time, and I will do that. One of the additional topics of this panel is what legislative fixes should Congress adopt. Increasingly, it becomes glaringly anomalous for there to be two different sets of legal regimes that apply to broadcast content and non-broadcast content. The most obvious example that people are familiar with is the FCC's indecency rules, which apply only to broadcast content. Economically, there's a more significant distinction out there between negotiation for rights between MVPDs on the one hand and either broadcasters on the other hand, or non-broadcast content sources. And the rule for non-broadcast content is actually, the regime is actually reasonably straightforward. You have straightforward licensing negotiations between HBO and various video platforms such as Comcast or OVD services such as Netflix. In the broadcast context, as many people in the room know, we have a much more baroque regime. We have retransmission consent combined with the compulsory copyright. The compulsory copyright regime was devised in the 70s. It's administered by the Library of Congress under rules that no one thinks are optimal anymore. And though the compulsory copyright regime applies only to cable systems, as that term is defined in the Copyright Act, it is generally assumed to exclude over-the-top video providers. Broadcast content is also subject to retransmission consent rights. If you're an MVPD and you want to air network programming and you want to air it in an area where there's a local broadcast station airing the same network programming, you have to enter into negotiation with that broadcaster about your ability to retransmit the broadcaster signals. Sometimes you may have to pay money to the broadcaster. And over the last few years, more money has begun to flow from MVPDs to broadcasters, and that's caused a variety of MVPDs to team up and argue that there's something broken about the regime. Money shouldn't be flowing, they say. That's bad for consumers. I just agree with that. The mere fact that money flows from one set of market actors to another doesn't necessarily mean anything. I think all it means here is that MVPDs perceive the content of broadcasters to be valuable, and they want to pay for it. And increasingly, the negotiations between MVPDs and broadcasters are really, in disguise, negotiations between the MVPDs and the broadcast networks. Broadcast networks are often very active behind the scenes and working with their affiliated broadcasters to extract fees from MVPDs. And that's efficient. What's inefficient is the fact that you have these broadcasters sitting in the middle as middlemen with respect to network programming. Obviously, local programming is a different set of issues, but there's nothing inherently wrong with having broadcast networks charge fees to MVPDs that want the broadcast network's content. This model applies, again, only to broadcast programming, and that is an arbitrary distinction. In a world where increasingly the broadcast model is declining and you're seeing more and more non-broadcast content reaching the homes of Americans. My long-term solution to that problem is not simply to reform the retransmission consent regime as many MVPDs have proposed, but also to, over time, and in a measured way, with a transition period, eliminate the compulsory copyright as well. So that negotiations between MVPDs or ISPs on the one hand and content providers on the other hand are unified, whether or not the content goes through one particular distribution channel or not. For those who are interested in this issue, there was a very good student note on this. I don't actually know the author. It's a very good student note on this issue in the most recent issue of the Federal Communications Law Journal, and I recommend it to all of you. Thank you.
John, you can stand or sit. It's your choice.
I guess I'll stand. Thank you, Stuart, for the chance to do this. Thank you for hosting this conference, which is extremely valuable, right? Because it gives us all a chance to exchange learnings and understand dynamics in the industries that we might not otherwise see. And it's a particular pleasure to be on a panel with the only members, other than Stuart, John and myself, since we've known each other for a long time. And we share so much in common. Spelling our first names without an H, working for independent agencies that have 3 letters, 1 F, 1 C. Let me take a few minutes to talk about modes of analysis. I agree with John about the importance of starting with economics. I've talked recently about the importance of econometric analysis of the kind that we've used. But I want to give you some personal views, and these are personal views, about some principles of governmental action and some analogies that one might look at to try to understand changes in the video world today. The mantra, competition, 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 by my count, there's 3 words in that, and I'm the 3rd person to have quoted it today. So it's important, right? Because in some sense, one can think of a governmental role as the focus on artificial barriers to competition and innovation. And they do exist, and government can unlock them. Here's a really simple example, right? When VoIP calling began to become more commonplace, the ability of VoIP providers to get telephone numbers was a significant step in making them effective competitors. So we look at those. And in this regard, I just want to say I thought the Assistant Attorney General's speech this morning was an extraordinary exposition on the nature of competition as we see it today in video and the threats to new competition. I appreciate the comments he made about the work between the Justice Department and the FCC, which has been very close and which I think has yielded important public benefits as a result of the discussions and harmonious working relationships. So we look for artificial barriers. Also, protecting consumers, right? A separate and important goal of the kind that's enshrined in the FTC Act, for example. Next, there are non-economic issues about which we care, about which Congress has instructed agencies to care. Localism in broadcast television is an important example. The desire to make sure that local news, for example, weather, community discussions are available. And then I think it's important to also look at the ecosystem in which product markets, geographic markets exist. In particular, I think there's it's interesting always to look at complementary markets for complementary products, right? Here, I'm thinking of the part of the Assistant Attorney General's speech this morning that talked about the relationships between the video marketplace and broadband distribution. And there are other examples. As we think about competition in this space, there are a couple of notable trends I think we've seen recently, some of which have been mentioned, but not yet by me. One of them was the fact that last year, for the first time, that set of companies we call the cable industry had more broadband customers than video customers. Right? That's important. It makes it somewhat of a misnomer to call it a cable industry. It's an industry that right now has more broadband customers. And of course, at the same time, we sometimes talk about other companies as broadband companies, although they are supplying important numbers of video customers. So that was an important step. Secondly, the nature of competition for high-speed broadband. As was already said earlier this year, the FCC found that high-speed broadband, what the chairman called table stakes for the 21st century, required a minimum of 25 megs down and 3 up. And at the time, we looked at the marketplace, 70% of American households had less than 2 alternatives. Some had 1, some had 0. And that's a cause for concern. And then, as 2014 drew to a close and 2015 entered, we saw interesting developments in the question of over-the-top video, right? I think early in 2014, there was a good deal of attention paid to disputes between Netflix and ISPs. But toward the end of that year and the beginning of this year, what we saw was the emergence, has been talked about, the emergence of new and differentiated kind of business models, right? Dish Sling, Sony View, HBO over the top, CBS over the top. And that leads us, I think, to think about a little bit about the business model of OTTs. What do OTTs need? Well, they obviously need programming. They need to be able to reach their consumers uninterfered with over a broadband transmission pathway. They may need access to devices, and of course they may be affected by retail terms and conditions on broadband access. These are all subjects that are worthy of discussion. But if OTTs can bring, or incumbents can bring, I think it's a very important point that was made on the last panel. We don't look to innovation from only one set of players in the marketplace, whether we call them incumbents, whether we call others insurgents. Obviously, we look for innovation and investment from all sources. But the dynamism of new business models, challenging old or earlier models, morphing into new ones, obviously offers a huge opportunity for increased consumer welfare from greater competition and from potential competition. So to the modes of analysis. As I said before, antitrust analysis is an important starting point. Econometric analysis, the expert views of economists are what we rely on when we start thinking about these issues. But I want to offer 2 additional, which are perhaps not as quantitative, but as we think about what the evolution of video might be, I suggest that there may also be some power in metaphors, at least to phrase questions, which is all I intend to do. So I'm going to do 2. One comes out of an article I wrote also for Phil Weiser's Journal at the University of Colorado a couple of years ago about the nature of value creation in the wireless, in the mobile industry, 2007 to say 2013. And I used the term of broadband value circle. Here's what I meant. Earlier, and 20th century traditional industrial organization, value chains, there's a supplier and then somebody below him, and then perhaps the entity, there's the retail relationship, right? General Motors talked to the customer. The developer of the windshield sold to General Motors, didn't have a direct relationship with the customer. What happened in the mobile sector at the end of the first decade of this century was, I think, a disruption of that. And the story can probably best be told by talking about Apple, right? Prior to the introduction of the iPhone in 2007, device manufacturers sometimes said that they had difficulty because they couldn't get to consumers directly, because they had between them and the consumers the wireless networks. Apple's introduction of the iPhone, of course, disrupted that. What Apple was able to do was to find a way of going directly to the customer and creating the most important relationship with the customer if that was the customer's choice, right? And in 2008, something else happened that was important. When Apple introduced its second generation of iPhone, on the same day it opened something that we had not heard of before called an apps store, right? Where third-party apps were available for use on these smartphones. And that unlocked a huge amount of competitive activity and innovation from a variety of apps developers who had not previously been in the market and were able to take advantage of the platform. It's obvious in this world, Apple thrived. The comparison is to device manufacturers who didn't make the shift as well. Nokia, Motorola. But what Apple was able to do, and what other people, and I only use Apple as one example, was to combine a direct relationship with consumers with the ability for consumers to assemble the elements they wanted, device, network, apps, self-generated content, in order to create a new value proposition for consumers in which the different creators, the device manufacturer, the networks, bargained for division of the surplus, right? So the question is, I posed this in this article a couple of years ago, is there anything going on in video that would be like or unlike that? Okay? And I suggested there were a couple of things to look at. I think I got some of the list right. I think I got some of it wrong. I'll do the right part first. First question was, would we see something where devices would assume greater importance to a consumer's retail experience? How much? One can speculate, but surely we have seen Apple TV with a new product. We have seen Amazon with a new product this fall. We've seen Roku and TiVo. We are seeing devices work on becoming very important to consumers in a very direct way. Secondly, at the time I wrote the article, there was very little original content that was being created over the top. But it's obvious now that there's a huge amount of content, right, and original content. And I suggested that might be interesting because it might tell us the extent to which these consumer relationships could be formed. And I think if we look at the Emmy Awards, and particularly if we consider HBO as also over the top, given its standalone product, huge impact of such video programming now. The third question I asked was, so consumers get to make their own packages, right? Think about your smartphone. It's a pretty unique combination of elements. It's a device, it's a network, it's the apps you want to use, no longer the apps you've decided no longer to use, it's your photographs, it's your own content. It's an extremely unique combination. And so one aspect I suggested of this kind of market was the ability of consumers to mix and match packages of their choice. I think the discussion today has suggested that some additional choices are coming to the marketplace. To say there are new choices is not to say that the old choices are not extremely good ones. But we are seeing, I think, some elements of consumers' ability to put together packages of their own creation. Two things I didn't ask about that I think I should have, and John touched on one of these, were IP rights, right? Where are the IP rights? To what extent are they important? To what extent are they efficiently able to be negotiated? What are the transaction costs? And then secondly, I was thinking about a world without advertising. And I understand there are platforms, video platforms, this was talked about earlier, I think it was Chris's point, that no longer advertising supported, but surely one cannot discount the continuing importance of those platforms that are advertising supported. So I offer this as a metaphor simply to say that one thing we can look at is whether these tenets might or might not, and I don't know the answer to it, be holding true in a video world. That is to say, different players, historically at different levels of distribution, each able to approach consumers with differentiated value propositions that consumers value and that in turn produces surplus to be bargained over by the different suppliers. The other analogy I'll use just very quickly, it's sort of interesting to ask about what happened to music, or what is happening to music, right? I mean, it's hard. I mean, there's huge amounts of great music being made right now. It's great. I mean, I know this, even though I'm at an age where I've noted that when younger people come up to me, they say in a slightly hesitant tone, you know, I like the Beatles. And I say, yeah, I like them too. But there's tremendous amounts of new music being made right now. The creativity is enormous. But the business model seems to be one that people think isn't quite working right. In inflation-adjusted dollars, recorded music sales have decreased by 70% since 1999. There's a lot of disputes going on, right? There's questions about streaming revenue, revenue from streaming. The Taylor Swift-Apple dialogue early in the year was very important in this respect. David Byrne of Talking Heads had an op-ed in the New York Times talking about what he thought was needed transparency in relations in the music business. There's obviously differences, big differences, right? Bandwidth requirements, the role of piracy in affecting the downturn in the music industry, particularly in early years. But it would be an interesting question to ask whether there is any similarities. Here's one question. When I've talked to people in the music industry, one of the things that they don't like, music producers in particular, is the fact that people don't buy albums the way they used to. And I had one music executive tell me a story about a young rock and roller in the 1970s who had recorded some tracks, and his record company thought the guy had promise, but hadn't really nailed it, and so gave him the money to do more tracks, and what came out was Bruce Springsteen, right, and his music of the early 70s. So there were obviously questions about cost structures if albums, sets of albums, get displaced by singles. And there are a lot of people in the music industry who don't like that and think that it's reduced their ability to produce quality product. If one looks at that, one could ask, are there any questions about units in the video business where consumer demand is changing cost structure? I don't know. I don't know if people are buying individual episodes instead of watching series. I don't know if cable companies are buying individual networks as opposed to buying packages of networks. But I just note that the music industry parable may help concentrate our attention on questions of cost structure and the impact of changing consumer demand, even though I don't suggest that the analogies in either respect are perfect, compelling, or I will say even right. Nor do I suggest that asking these questions means there's any particular role for regulatory action. That's a separate conversation. But what I appreciate about what Stuart's done today is to invite us to have a conversation where we offer thoughts about what's happening, which does seem to me like an important first step. Thanks very much.
So, in the interest of getting questions from the audience, I will ask one reasonably short question, I hope, and then we'll get the microphone around. Are there any developments that either of you could foresee where, or where you could say, okay, by my metrics, now the world has changed? So, are there situations that can arise that seem reasonable where you could say, boy, I think for regulatory purposes, we've now undergone a shift? For either one of you, is there something you can realistically imagine that would lead you to feel like we've now had a tectonic shift here?
Yes, if wireless became fully competitive with landline for broadband internet access.
I think that's a good example, right? So in the 1990s, when the first Section 271 applications were being filed for Bell Company entry into long distance, the question came about, what was the market share of the incumbent local exchange carrier? And in the initial applications, the carriers argued that mobile should be counted. And at the time, right, I was at MCI, at the time, it didn't appear that the usage of mobile then was a substitute for landline. I think that was the right decision. But times change, market conditions change. We don't believe right now that mobile broadband is a full substitute for fixed. But John's point is a critical one. One needs to look at markets as they evolve and make judgments accordingly.
So now let me throw it open to people here. Steve, yes.
So I'm going to ask another internet question. If the mantra is, it's good, and I think everyone would agree, competition, 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 when I look at the terrestrial market, I'm going to pause it for a second that mobile is not going to be a substitute. When we run the math using the FCC data, it suggests that to do a fiber overbuild like Google is doing at prevailing rates, you need a 50% attach rate just to generate zero economic profit. And the corollary of that is that nobody's really going to do it, okay? So then I say, well, when would someone do it? And I would say, well, broadband prices go up. Then there'd be an economic incentive to get more fiber overbuilds. Then my head goes back to Title II and sort of these issues of foreclosure, and I say, gee, if the cable operators start raising prices, and I think they're doing it not to act as monopolists, but to just recapture lost gross profit on video, the risk is that the FCC comes in and says, oh, you're trying to foreclose competition from the OVDs, we're going to rate regulate, and at the end of the day, you end up never seeing what the government ultimately wants, I think, which is a fiber overbuilder to bring more competition. So the question is, how does the government look at the potential for us to enter a window that's actually quite difficult, where it looks like someone's trying to foreclose a market and foreclose the long-term optionality to have multiple facilities-based broadband providers?
I don't know about the whole government, but I'll give you a view of my way. We want innovation, as I said, from all sources. That requires investment. It requires investment in networks. The Commission's goal is to incent. The Commission's goal is, you want me to start again? We want investment from all sources. We want innovation from all sources. The chairman has been very plain. The Open Internet Order doesn't regulate, and it won't regulate retail rates. There's no tariffing requirement in it. John made note of the fact that in the years when mobile voice was the prime driver of mobile services, the application of Title II did not result in price regulation, did not deter investment. We're in the same situation. The Commission has said and is applying light touch regulation suitable for the requirements of the 21st century, which include, very importantly, continued network investment.
I would echo something John said, which is, I understand the economic concern. I think that the question of Title II or not Title II isn't really that relevant. You can imagine a spectrum of degree of regulation with completely unregulated on one end and traditional New Deal era command and control price regulation on the other end. Before Title II reclassification, the existing regime was somewhere in the middle, but closer to the deregulated side. After Title II deregulation, it's in about the same place. It may have shifted a little bit, but not very much. The main concern is not that the mere fact of reclassification increases the prospect of economically inefficient regulation. The concern is that it lays the groundwork for future commissions to do that. But future commissions could have done that anyway. And for that matter, you could have rate regulation under other sources of FCC authority. For example, under 706, I don't know whether it would be considered a form of common carrier regulation to impose rate caps or to prevent price gouging by ISPs. Maybe it would have been. My only point here is that reclassification has been somewhat overblown as an important economic event. I don't really think that by itself it is.
Stephen, if you could identify yourself. That was Jason Bazinet for everybody's benefit, yes.
Hi, how's it going? Will Reinhardt, American Action Forum. I do some analysis on these kinds of topics. I was wondering, you guys talked about the substitutability of wired versus wireless. I'm wondering, I mean, there's at least some good models out there right now that have looked at this substitutability, and at least on the margins, there is actually some competition on quality. So at what point does the marginal competition for you transfer into the perfectly substitutable competition, or at least substitutable competition that you're talking about?
Too hypothetical for anybody in the room except the FCC chief economist, David Waterman.
Can you repeat the question?
Okay, it's okay. No, I
mean, the relevant question is when. I mean, you could do a full-blown economic analysis of this issue to determine whether or not they coexist in the same market. You could do a snip test. Right now, I don't think you see sizable numbers of consumers cutting their landline broadband connections to go mobile only on the theory that they are close substitutes. It may be different in other countries. I think Christopher pointed out that in Australia there's more substitution than there is here. But that doesn't mean that we won't get there. We might get there, and I wouldn't underestimate the ability of engineers to make wireless a closer substitute than to wireline than it is today. There are lots of interesting things that engineers can do, even with constrained spectrum, to duplicate the experience of wire connections. But we're not there yet.
Right. I mean, just to say, just two factors, but it's important to look at all the factors in what affects consumer choice. We don't believe mobile broadband is a full substitute, in part because of technical limitations, but also in part for pricing, right? What it would cost on a wireless network as opposed to a fixed broadband network to consume the same amount of data.
Yeah, and that's an important point. Obviously, if you don't have other users on a wireless network, you can easily duplicate the experience of wireline. The problem is that that's not a cost-efficient means of running a wireless business. At present, could change.
So tragically, we are at the end of our time. We have to go to our last thing, which is Frank Pallone. So I want to thank the Johns for an excellent panel.
The Johns.